Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. This is the first of a two-part series on the June 26, 2025 redacted memorandum decision and order on the defendant's motion to continue. There are three principal arguments that the court is addressing. First, Mr. Kohberger asserts that the volume of discovery continues to pose a challenge to his counsel's ability to timely and meaningfully review all of it. Third, he asserts that recent and forthcoming publicity on the case is highly prejudicial. And then sandwiched in between is the part that we're going to address in the next segment, which is he asserts that there is penalty phase investigation and preparation that still needs to be done. With respect to the first argument, the court here, after going through on pages 1, 2, and then the top of 3, the legal standard regarding continuances and what a court must do to ensure that a party's constitutional privileges are not violated, goes into the first argument that defendant has not demonstrated a continuance is warranted to review discovery. According to Judge Hippler, the defendant contends that the vast amount of discovery in this case renders it impossible for the defense team to review the necessary and relevant discovery in a manner that allows for it to be comprehensively integrated into his defense, and further argues without any support or explanation that there are, quote, a myriad of issues that continue to arise from the state's failing to comply with discovery and expert disclosure deadlines. Continuance, he argues, is necessary for counsel to mount an effective defense. The court, however, rejected this same argument 2 months ago. Judge Hippler says, in its order, approximately 2 months ago, the court observed the utter lack of any proof supporting defendant's accusations of discovery violations by the state. And then more importantly, the court found defendant's complaints of being unable to meaningfully review discovery entirely unconvincing, pointing out that counsel struggled to articulate in any meaningful way what evidence, let alone relevant evidence, counsel has been unable to review over the past 2+ years, and why basically counsel had not spoken up sooner. This motion should have been made when the claimed problem had become apparent, and certainly should have been brought prior to the expiration of discovery, all expert deadlines in the final pretrial conference. Instead, defense counsel has robustly litigated this case, retaining approximately 24 experts, full mitigation team, engaging in extensive motion practice, and disclosing witnesses and exhibits with nary a whisper that a continuance would be sought. So it seems as though the court's saying a little too little, a little too late, and has denied that first grounds to continue the case. I want to go ahead to the issue that I, in my opinion, thought that was the strongest, which is all of the pretrial publicity, all of the prejudice, and the fact, quite frankly, that the court had found that someone violated the non-dissemination order by apparently providing to mainstream media some documentation from the court files that might not have even been admissible as to the issue of this pretrial publicity. Judge Hippler believes that there are ways to get past the concern about seating an impartial jury. The court here describes some very robust safeguards that are put into place to ensure that anyone who has any partiality and is biased against Mr. Kohberger will not get a seat on the panel. The defendant's right to a fair trial is not denied by the pretrial publicity, which is not likely to subside with time. Judge Hippler discusses on page 14, goes into the Shepard versus Maxwell case, the 1966 case that we had addressed before from the U.S. Supreme Court. The court has rejected this and feels that there are sufficient safeguards in place to ensure an impartial jury, and that is what is required per Judge Hippler under the Constitution. This will now conclude part 1 of this 2-part series. This is Kathy. Thank you for joining us here today.